Welcome back to another explainer. Let's be real. If you've ever found yourself totally lost in a sea of assigners, assignees, delegators, and delegatees while prepping for a law exam, you are absolutely not alone. It's like a giant puzzle. Today, we're unpacking exactly how modern commercial law handles the transfer of rights and duties, and why mastering these specific case briefs is literally the key to surviving your contract's final. Let's dive in.
All right, to start, it really helps to get our timeline straight. We're looking at what happens after a contract is already formed. A baseline agreement already exists, but now one of the original parties wants to bring a brand new actor into the ecosystem. This fundamentally changes the original dynamic, taking a simple two-party contract and turning it into a three-party triangle.
Here is our agenda for today. 1. Rights versus contract duties. 2. Assigning rights, the rules. 3. Delegating duties and limitations. 4. Liability after delegation. And finally, 5. Test your contract's knowledge.
Okay, kicking things off with Section 1, Rights versus Contract Duties. I know the terminology often gets completely jumbled up in your head, but for exam analysis, the distinction is absolutely crucial. You assign a right, which is usually the right to receive something, like getting paid, but you delegate a duty, the actual operational obligation to go out and do a task. So think about it. If a contractor hires someone else to lay bricks, is that an assignment or a delegation? Well, it's a delegation of a duty. Remember, rights are assigned, duties are delegated.
Now, historically speaking, the old common law doctrine of privity of contract was a massive roadblock here. Privity basically meant that only the original people who actually signed the contract could enforce it. Adding third parties into the mix created huge conceptual problems. But, modern commercial law, especially things like the Uniform Commercial Code, aggressively favors the free flow of commerce, so the law had to evolve. We had to find a way to let people trade their contract rights just like they'd trade physical property.
Moving right along to Section 2, Assigning Rights, the rules.
So when a valid assignment is made, the transferor's right to receive performance is totally extinguished. It vanishes, vesting entirely in the new assignee. But here is the key test you're going to face as a student. To execute this properly, the assigner must manifest a present intent. To transfer, if someone tells you, hey, I will assign this to you tomorrow, does that work? No way. That is just a promise to do something in the future. But saying, I hereby assign this to you right now, that's a valid legal transfer, right then and there.
Let's see how this actually plays out in the real world with Aldana v. Colonial Plaza. Briefing cases like this is critical because they reveal those classic traps professors love to set. Here, a tenant had a lease with an anti-assignment clause that basically said they couldn't assign the lease. But the tenant went ahead and assigned an $8,000 construction allowance to Aldana anyway. The landlord naturally refused to pay Aldana, pointing straight at the clause. But the court said, not so fast. Under Restatement Section 322, simply banning the assignment of the contract only stops the delegation of duties. It does not stop someone from assigning their right to receive a payment. So the landlord had to pay up.
A valid assignment fundamentally shifts who actually holds the power. Just look at Herzog the iRace. A client assigned his future settlement money to Dr. Herzog to pay for a shoulder surgery. But when the settlement check finally came in, the client completely flipped and told his lawyers, don't pay the doctor, give the money directly to me. So who do the lawyers legally have to pay? The holding here is honestly pretty striking. Once an obligor has notice of a valid assignment, they must pay the assignee. The lawyers were ethically and legally bound to pay the doctor, completely overriding their own client's direct instructions.
Which brings us to Section 3, Delegating Duties and Limitations.
Now we're shifting from getting paid to the much trickier territory of actually doing the work. I absolutely love this quote, cited in the McCanney v. Pizza case, which was all about delegating the duty to maintain vending machines. It goes, all painters do not paint portraits like Sir Joshua Reynolds, but rare genius and extraordinary skill are not indispensable to the workmanlike digging down of a sandhill. The underlying question you have to ask is this: does the duty involve a truly unique personal skill or a special trust? If it doesn't, like say refilling a pizza shop's vending machines, then it's just a sandhill. It is perfectly delegable.
But you can't just delegate everything willy-nilly. There are strict limitations, especially under the Uniform Commercial Code. Look at the corporate rivalry in Sally Beauty v. Nexus. Nexus had a distribution contract with a company called Best Barber. But then Best Barber was bought out by Sally Beauty, which just so happened to be a wholly owned subsidiary of Alberto Culver, a massive direct competitor to Nexus. Under UCC Section 2210, you cannot delegate performance if the other party has a substantial interest in having the original promisor perform. You simply cannot force a company to accept the best efforts of their direct competitor's subsidiary, so the delegation was blocked.
All right, Section 4, liability after delegation. Let's walk through the timeline of Rosenberg v. Sun, because this addresses one of the most common student misconceptions out there. Pratt bought a Dairy Queen from the Rosenbergs on a payment plan. Sometime later, Pratt assigned her rights and delegated her duties to pay to a new company called Sun Inc. Pratt packed up and moved to Arizona, thinking she was totally free and clear of the whole deal. But did delegating her duty actually erase her liability? Absolutely not. Unless the original creditor signs a formal, explicit release, which is called a novation, the delegator remains legally bound. They're basically on the hook as an involuntary surety. Since the Rosenbergs never agreed to a novation, Pratt was still on the hook when the new buyers defaulted.
So, how does the other side react to a delegation? In Seal v. Bates, a couple bought dance lessons from Bates, but Bates ended up transferring the contract to Dale Studios. The couple was super unhappy about the change, but, well, they went ahead and took 30 lessons at the new studio anyway, before finally deciding to sue. The reason this case is so important is that it teaches us all about waiver. The court held that by not objecting immediately, by actually accepting the substituted performance for 30 lessons, the students legally waived their right to complain later that a non-assignable personal service contract had been breached. The lesson? If you don't like a delegation, do not accept the performance.
Finally, Section 5. Test your contract's knowledge. I want you to read this hypothetical carefully. It's based directly on the case of Associates Loan v. Walker. A farmer buys a water softener from a seller. Crucially, they orally agree that the farmer only has to pay for the machine if it actually increases his cow's milk production. The farmer then signs a written contract. The seller immediately assigns the right to payment over to a loan company. Well, the water softener is a complete dud. The loan company comes knocking, demanding payment from the farmer. Pause for a second and really think about this. Can the assignee, the loan company, force the farmer to pay?
And the answer is no. And here is the exact rationale you're going to need for your exam. An assignee simply steps right into the shoes of the assignor. They acquire absolutely nothing more than the assignor had in the first place, and they inherit all the exact same vulnerabilities. Because the original seller was subject to that oral condition that the machine actually had to work, the loan company takes the contract subject to that exact same defense. Since the condition failed, the farmer doesn't owe the seller a dime, which means the farmer doesn't owe the assignee anything either.
As we wrap up this explainer, it's fascinating to pull these textbook concepts out of the classroom and into the real world. Every single time corporations merge or businesses are sold off, rights are being assigned and duties are being delegated behind the scenes. Just consider your own life for a minute. How many hidden assignments currently exist in your daily software subscriptions, your apartment lease, or your digital accounts right now? Have your personal data rights been assigned to a third party without you even realizing it? Keep that in mind the next time you blindly click I agree. Thanks so much for exploring this with me today, and good luck with your studies.